Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers, with Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Good morning. Welcome to Law Power Hour. Tomorrow's daylight saving time, so set your clocks forward 1 hour, please. If you remember when you get up in the morning, set them forward an hour. It's going to be a little bit of a change for a week or so for us to adjust to the change in daylight savings time, but it's exciting because spring's just around the corner. On that note, it looks like a great day today. And for those of you who have legal questions, come on down to a program that we're putting on this afternoon at 12048 Grand River. That's 12048 Grand River on the corner of Wyoming and Grand River. I'll be there from 3 to 6. There should be other attorneys there. And maybe the Ombudsman of Detroit will be there to answer legal questions and give you information that will help you in your daily affairs. Last week, at the end of the show, I had a call from one of our listeners who requested that I continue on talking about Social Security disability. Next week, we'll have a live guest on with me. But this week, you've just got me again, so if you've got questions about Social Security, I know it's a very complex process, but I want to make sure that you've got all this down. First and foremost, I want you to know that you can apply online without the assistance of a lawyer. But if you need the assistance of a lawyer, do not get a lawyer. Do not get a lawyer who is not in your area. In other words, don't get an online lawyer from Wisconsin who will travel in by plane to handle your hearing, or from Cincinnati, Ohio for the same reason. Get a lawyer that you can go in and talk to about your case. And it's very important to have that opportunity to talk to a lawyer when you're applying for Social Security disability. If you have a computer, you can go online and fill out your initial application. But let me give you some advice. It's not the best idea. It's not the best idea to go online and do that by yourself. The best thing is to make an appointment to see a lawyer or a law firm that's qualified to handle Social Security disability and SSI cases so that you have a better appreciation and understanding of what you need to prove in order to get benefits. When you make an appointment to see a lawyer, bring the following information with you. It's very, very important to bring it with you. Bring proof of your birth. Bring a Social Security card with you. Your marital status, whether you're married or divorced. Information about minor dependent children or disabled children who are over the age of 18. And medical information. One of the biggest problems in applying for Social Security disability is the failure to have adequate medical information with you when you apply. When you go see a lawyer, you should have a list of the hospitals that you've been to, the doctors that you've treated with, the clinics that you've gone to, the places where you've had diagnostic testing, because it's all material in handling your case. There are two parts to Social Security. One is the medical eligibility portion, and the other is the disability application entitlement portion. On the application, you need to meet certain requirements for Social Security disability. We talked about the 20-40 rule before, but I'll repeat it again today. You've got to work 20 out of 40 quarters. That means you have to work 5 out of 10 years. That rule only applies to individuals who are over the age of 31. If you're under the age of 31 and you're disabled, for example, if you're disabled between the ages of 18 and 24, all you need is 6 credits. That means if you worked 3 years, you'd have 12 credits, 4 credits a year. You'd only need a year and a half of employment during that period of time to apply. Between the ages of 24 and 31, you need half of the credits for the period in order to receive an application for benefits eligibility. Not entitlement. Entitlement's a different word. This is just to make you eligible to apply for Social Security disability. Let me give you an example. If you're 27 years old and you're applying for Social Security disability and you've worked 3 years, you would have enough credits at that point to apply for Social Security disability. Because 3 years out of the 6 years would be enough to apply. That's 12 credits to apply for Social Security. Now, In order to get a credit, you have to earn about $1,400 a month for each quarter to get a credit. That doesn't sound like a lot of money, but I'd rather have a situation where you were making higher wages working full-time, and if you became disabled during that period of time, that you apply. Now, why is this really important for you to know? Because a lot of people start the process and they stop the process. They stop the process before they clearly understand why they've been turned down. And if you stop the process, if you stop your application, your past due benefits will not come to you. You'll lose them and you have to reapply. And when you reapply, if you waited more than 60 days, the Social Security Administration will make you start right at the very beginning. So we're talking about two types of eligibility. One is the eligibility based upon your earnings and the quarters that you've worked. And the other is your medical eligibility. Last week I was trying to explain, and hopefully I got the message down, but I'm going to go over it again. When you apply for Social Security disability, it's not just the medical records that you have that will assist you in getting your benefits. It's documentation. And by documentation, I mean the following. If you're an epileptic or a diabetic and you have seizures, not only do you need a letter from the doctor, but you need someone who's close to you and your family to sign an affidavit, come with you to the hearing, and indicate that they've observed you having seizures. This is very, very important information to have in addition to the medical records and reports. Additionally, if you bring in medical records from doctors, it's not enough just to have medical records. It's not enough for you just to get the reports from the doctor and say, well, the doctor said I can't work. The doctor's got to explain why you can't work. The doctor, he or she, has to put down in writing why you can't work on a regular, sustained basis. Now, with all this information being submitted, it goes through a review process, through the state agency. As I pointed out to you, the state agency uses their own doctors to review the records. And when they review the records, they'll put a stamp on it. Disabled, not disabled, or alternatively, there's a need for a consultative examination. Let me explain to you what a consultative examination is. That's when the Social Security Administration says you need to see a doctor because we want you evaluated. We want you checked out to see what your disability is. So they'll set up an appointment with you to see one of their doctors. Well, these doctors don't spend but 15 minutes or 20 minutes evaluating you unless they have to run some diagnostic tests. So this is why you need a lawyer to help you. If you have a lawyer, a good lawyer worth his or her fee is going to tell you the following. When you go to a consulting exam, bring your medical records with you so that the consultative examiner has those records in front of them to review. Recently, I reviewed a case where a woman had trigger fingers. She couldn't hold on to things because her fingers locked up all the time. Well, she had surgery on her left hand, but she also had trigger finger in her right hand. So the doctor never paid attention to what was going on the right hand because she didn't bring any medical records, didn't have any proof of it, didn't have a letter from the doctor saying why she could or she couldn't work. So if you have that at the baseline, when you go to the examiner for an evaluation, then the examiner who's hired by the state's in a better position to understand what's going on with your case. Likewise, bring all your medication with you. If you bring the list of your medication with you and how often you have to take the medicine and what it's for, then the doctor can put that in his report or her report and indicate when you were examined exactly what was going on. Because they're going to formulate an opinion. In other words, at the end of their examination, they're going to make a decision as to whether you're disabled or you're not disabled or whether you need restrictions in the workplace. And the more information you provide them, the better off you're going to stand a chance of getting your benefits. This works for both claims, whether it's an SSI claim or an SSDIB claim. SSI is a supplemental benefit that is available for individuals who do not have earnings to qualify for Social Security disability. On the SSI application, the only difference between the two is that there's no earnings and there's no assets available. You can have up to $2,000 in assets. You can own a home. You can own a car. But if you have no other assets and you haven't worked, you can still file for SSI. For SSDIB, it doesn't matter if you have money in the bank, if you have the earnings quarters that entitle you to make the application for benefits. These are eligibility factors. In order to get an award, you have to get a certification that you're disabled and you can't work. You cannot go back to work on a sustained competitive basis for at least 12 months. And you get paid from the 6th month of disability. Now, someone asked me, can I draw SSI and work? The answer to the question is, yes, you can work while you're drawing SSI. There's a maximum income of approximately $1,400 a month that you can receive in a combination of your SSI and your earnings. But make sure that you're not working on a full-time basis if you can't work on a full-time basis, because then you'll be engaged in sustained competitive activity. And believe me, if you can do it, go to work and do it, because you may eventually earn enough quarters if you've got to apply for Social Security disability. If you can't work on a full-time basis and you're working part-time, you can earn up to $1,400. If you're drawing Social Security disability benefits, you can earn another $1,100 per month. I believe that's the number I wrote down. Yeah, it's $1,100 a month maximum before you lose your right to Social Security disability. But you have to report your earnings. Now, the key in applying, I'm going to go over this again, is having an accurate set of medical documents. It applies to adults, it applies to children. If a child is receiving benefits and a child is in a household where there's one parent who's working, then you can receive benefits up to a maximum of $3,200 per month, $3,125 a month. And there'd still be a household benefit available if there's a family. In other words, husband and wife and a disabled child. There can be family earnings up to $3,870 a month and still draw SSI. I'm going to go back on this SSI issue for children and talk about what is required to get benefits. As I pointed out to you a couple weeks ago, one of the most important factors, and if you have any questions about Social Security, call in, because we're going to answer all of them today. If a child is receiving bad marks in school and is having trouble, and you're required to go in on an IEP, in other words, you're required to go in by the school for an evaluation plan, individual evaluation plan for your child. The school, by that time, has had a battery of tests performed on your child, has met with counselors, has met with psychologists, and when they sit down to meet with you about putting your child into a special ed program, then you may still need assistance in other respects, so you remain eligible to receive SSI benefits. The IEP will provide you with additional information that will assist you in applying for benefits for your child. And children's benefits are very, very important. They can receive children's benefits up to the age of 18. And after the age of 18, unless they're severely, God forbid, severely handicapped and disabled, then they automatically would receive benefits. Otherwise, they have to reapply for benefits as an adult. And a child applying for benefits and an adult are applying for benefits, quite different, because the criteria is quite different. So it becomes very important when you're applying for Social Security disability benefits to be knowledgeable as to what's going on in applying. The most important thing I'm going to tell you today is when you start the process, seek the assistance of legal counsel. There are many of us out there who are well qualified to assist you with your application. If you don't know an attorney who's qualified, then you can go to the Yellow Pages, or you can go on the internet, or you can call my office at 248-335-9266, and we have qualified individuals who will help you with your application for disability benefits. If you are on a disability from work and you're receiving short-term disability benefits, you may be required under the insurance disability agreement to apply for Social Security disability. You will need the assistance of an attorney to apply for Social Security disability benefits. Some of the larger insurance companies who write disability for the big three have attorneys that they contract with to handle these cases. That relationship, while it's okay, is not the same as being able to pick up the phone and talk to a live body. Talk to a live body in an office and get information on your case. When you can pick up the phone and ask questions, or you can make an appointment if you're reviewing your case and get a better understanding of what you need to qualify for benefits, you're further ahead. Additionally, if you're involved in an accident and you're receiving wage loss benefits, by law, if you're off 1 year, you must apply for Social Security disability benefits because the no-fault carrier is entitled to reimbursement. The no-fault carrier is entitled to be paid back if you receive Social Security disability out of the first benefits that you receive. Now, I'm going to take you through the hearing process. So you've completed all of your applications. You get a notice that you're going to go to a hearing. And you believe that your attorney has all of your medical information. So the first thing that you should do is schedule an appointment with your attorney to review your case and prepare for your hearing. How do I prepare for a hearing? You come in and you have a meeting with the attorney. And the attorney will tell you how to dress when you come to the Social Security Administration for your hearing. Appearance is very important. You don't want to walk into that room with a knee brace and a back brace and a neck brace on if you don't wear them every day and there is no prescription for them. You don't want to walk in with a cane and you've never got a prescription for a cane unless you need that cane and you have a prescription. One of the tricks that the administrative law judges use if you walk in with a cane is they may want to look at that cane to see if the bottom of the cane's got a new rubber butt on the bottom of it, to see if it's worn out or it's ever been used. So you don't come in with things that are not prescribed, because the judges have to make what we call a credibility assessment. A credibility assessment is whether they believe you when you're at the hearing. So if you come in with a brace around your neck and you don't need it, what do you think the judge is going to believe? That you're overstating your position. If you come in with a back brace and that back brace is tucked all around you, you see me pulling my coat together here, and you say you've got to wear that every day, they're not going to believe you unless you got a prescription from the doctor. The same thing with a knee brace or coming in a scooter. They're not going to believe you unless you have a prescription from the doctor for these items. Because it's going to be the first time that the administrative law judge is going to have an eye-to-eye presentation. They're going to look at you and you're going to look at them. You're going to formulate your opinions. They're going to formulate their opinions. And what we have to do is we have to cure this issue on the credibility. Cure it early. And the best way to cure it early is come in with prescriptions if you wear appliances. If you have a TENS unit, which is a nerve stimulator unit, and you're wearing it every day, and you have a prescription for it, you bring it with you. So when you go to the attorney and you're using these implements, make sure that you and the attorney talk about the need for a prescription from the doctor, and you submit that before the hearing. There is a rule, Social Security rule in place now, that any medical that's submitted at the hearing will not be accepted unless there's a specific extenuating reason for it. And here's an example. Let's say that you're supposed to go to hearing on April the 15th, and on April the 6th, 9 days before your hearing, you've got to go to the emergency room and you've got to get that record. Well, then there would be a reason why you might be able to bring in those late records. Otherwise, everything has to be submitted at least at a minimum of 10 days before the hearing. And remember, I told you when you go to the hearing, they want a pre-hearing submission statement submitted. Question: how can you accurately submit a pre-hearing submission statement unless you sit down and talk with your attorney and help your attorney prepare that statement? How can you accurately tell the judge that you've got problems, that your medication has side effects, unless there's documentation of the side effects of your medication? How do you get documentation? You go to the doctor and say, "Doctor, I can't take this medicine. It's making me sick." Or, "Doctor, I take this medicine and I can't drive." Or, "Doctor, I take this medicine and it makes me sleepy during the day." It's in the doctor's notes. It's there to be seen, and then it becomes a little more believable. Now, after you've done that, after you've accomplished that part of it, and you've gone in and talked with the attorney's going to tell you how to dress, what you need to bring with you to the hearing, bring your medicines with you to the hearing. Make sure when you bring your medicines to the hearing that you have them on a list and you can explain what the medications are for. You don't have to be a pharmacist to do this. You ought to know what you're putting in your mouth. If you can't remember the name of it, fill up a plastic bag, put all of them in the plastic bag, and bring them with you so you can show the judge what you're taking every day. And if the medicine has side effects, tell your attorney so that when the attorney is writing a report for you, the attorney has this information to put into the report. I'm not going to give you a list of medicines because I'm not a pharmacist, but I'm going to tell you there are side effects to many medications that will affect you and your ability to receive benefits. Some of these side effects will require you to have a witness at the hearing with you to talk about those. Okay, so you're getting ready for the hearing. Getting ready for the hearing and your interview with your attorney after you provide the information requires an explanation of what goes on at the hearing. There's an administrative law judge. There's a court reporter. There's a vocational expert. And I explained to you last week that the vocational expert is there to evaluate your jobs. So you need to explain what you did on your job. And you just can't explain it. And I said, you just can't explain it by saying, I pressed a button. No. You've got to tell them whether it was a sit-stand job, whether it required repetitive use of your hands, whether there was twisting and turning and pulling and lifting, and how much you had to lift occasionally, how much you had to lift frequently, how often you had to do this, whether your job required you to stack and rack and transport parts from one station to another station, whether your job required you to sit and write for 6.5 out of 8 hours a day, whether your job, for example, let's say you were a transporter and you can't work as a transporter. That means that you had to push people in wheelchairs, assist them getting on buses, getting off buses. Those kind of things are really important in handling your case. So the details in handling your Social Security case are going to make the difference in how your case turns out. And your attorney should be prepared to spend a little bit of time going over the hearing process with you. Because everybody who's applying for disability benefits needs those benefits, otherwise they wouldn't be applying. Everybody who needs those benefits gets a little nervous about their case because they've never appeared in front of an administrative law judge and they wouldn't know They wouldn't know what is going on in terms of the hearing unless somebody explains the hearing process. So the way the hearing goes, the judge will make preliminary remarks about the case that has to do with eligibility. In other words, is this a SSI case or SSDIB case? They'll cover the date you're last insured. That means the date you're last eligible to receive benefits. Then there'll be a summary of the documents in the file, and your attorney should have reviewed the Social Security file. They need a code number to access the files from the Social Security Administration, and they can go online and review your file in detail. And then the administrative law judge will start asking you questions. And the preliminary questions are real simple. They get your age, your education, your marital status, your past employment for 15 years. So you need to know all this information. You need to go over this with your attorney. And then they start talking about what you did on each job. Whether you were a supervisor, whether you were a foreman or a worker, whether you were a manager or a clerical person, for example. These are all important factors. They're called relevant vocational factors. And then when you get down to talking about your disability, the judge is going to ask you to explain why you can't work. And if you say, I can't work because I hurt, that's not going to work. I can't work because I have a problem with my arms. It causes me pain. Is different than saying I can't work because I hurt. But then you're going to have to explain what the problem is with your arms. And then the judge is going to ask you a question. Can you lift a gallon of milk off a table? A gallon of milk weighs 5 pounds. They know it weighs 5 pounds. And if you say yes, you better not stop there. You better say, I cannot lift it on a regular basis. I might be able to lift that gallon of milk once every half an hour. And remember what I am telling you. Don't forget, when you're in the hearing room, it's your hearing, so you can have as much time as you need to explain yourself. If you cannot hold a pen, and here's a pen, if you can't hold this pen in your hand and write with it because your hand cramps, you need to explain why you can't write with it. If you cannot sit, if you're doing computer work, and perform computer work with your hands at the desk because of the pain in your wrist, you need to explain why you have the pain in your wrist and what activity causes the pain in your wrist and what happens when you're not at the computer. If you say, if I'm not at the computer, my hands are at rest, I'm fine, then you're still in trouble because there's other work that you could do that's not computer work. Remember, it all becomes relative as to what you did in your past employment, what you can do, what you cannot do. So if you're under the age of 55, that's that magic age where it's pretty difficult to retrain you. They're going to find a job for you unless you have problems that are diagnosed and there's objective evidence of your condition. Now, objective evidence means that you have a diagnostic test. That could be an MRI, that could be a CAT scan, it could be x-rays. But not only do you need those tests, you need a statement from the person interpreting those tests indicating how that diagnostic test confirms that you're having a problem. I'll make it real simple for you. You apply for benefits, you've got trouble with your back and your neck. The judge says, well, Mr. Keller, why can't you work? I've got a pinched nerve in my neck and my back. That's not going to do it. You're going to need diagnostic tests indicating what problems you have because of the pinched nerve. You're going to need a letter from a doctor stating what problems you're having because of the pinched nerve. You're going to need verification of the medication that you're taking and how that medication affects you to help with the discomfort that you have from the pinched nerve. So these are the fine points that your attorney will discuss with you in preparing you for the hearing. If you have an emotional problem and you tell the judge, I can't work because I can't stand to be around people, then they're going to say you can work at a job where you have low contact. But if you tell the judge that you're incapable of working with people, taking instructions, following instructions, remembering what you're doing, or staying on task, and you can explain why you can't stay on task, for example. Why you can't concentrate and stay on task. Because of headaches. Because of your medicine. Because you're daydreaming. Whatever it is, if it makes sense and it's documented from the doctors, then you have a better chance of getting your benefits. These are all important in preparing your case. So after the judge asks all of their questions, then the attorneys get their chance to come in and ask questions. And they should be asking questions to fill in the blanks that are left out. If the judge says, can you lift a half a gallon of milk, and you answer yes, then the attorney should be asking you, how frequently can you lift it? When's the last time you lifted a half gallon or a gallon of milk? When's the last time that you performed any repetitive activity? And this is where you're going to run into trouble. If you can do your own laundry, the judge is going to assume that you can fold up. Yeah, I'm turning my hand over. Fold up sheets. Fold up towels. Put your laundry away and draw the conclusion if you can do your laundry, you can do some work. Or the judge is going to draw the conclusion, if you say you can go to the store, that you can drive to the store, you can do your grocery shopping, and you can take your bags out of your car. Therefore, you're employable because the things you're doing in your personal life are what we call identifiable, transferable skills to the workforce. So if you can't do your grocery shopping and somebody has to take you grocery shopping, bring that person to the hearing. If you can't zip up your coat or put on your undergarments because you can't use your hands, bring that person to the hearing to testify. It becomes important and relevant to verifying the claims. Another example, if you can't work, but you can go to the church and help out at the church with the bake sale, the catering, breakfast every Sunday morning, make the coffee, run the errands at the church, or the synagogue, they're not going to find you disabled because you're doing things that you want to do, and they're going to determine that you're employable. Now, the last area in the hearing where you're going to get caught in the trap is if you say you're disabled and you go out and you socialize. For example, you can drive the car. That means that you got to put clothes on and get behind the wheel of the car. And you can go visit your brothers and sisters, nieces and nephews, or your mom and dad 2-3 times a week. If you're capable of doing that, more likely than not, you're capable of driving to and from a job and working. But if you can't go out and people have to come to your house to visit you, that's an indicator that you're incapable of getting out and doing things. And if you can't go to the grocery store and people have to do your groceries, or if you can't do your laundry and people have to do your laundries, and if you live in a 2-story house and your bedroom's upstairs and you can walk the stairs and use a bathroom upstairs and there's no bathroom downstairs, that's an indicator that you can go up and downstairs during the day. It's not an indicator that you have the struggle. But you can have the struggle. I mean, you don't have to have a porta potty in the house to get benefits. But you can have the struggle. And if you have the struggle, you've got to be able to explain the struggle to the judge in order to get your benefits. So these are common issues that show up. Now, I haven't had any calls today, so I hope you're listening, because I'm trying to educate you on how to handle your case at the hearing. So when we get to the final level here at the hearing, the vocational expert is called upon, and they have done a vocational analysis of your past employment before the hearing. And they will classify your work as sedentary, meaning that you sit for 6.5 out of 8 hours a day, light, up to 10 pounds, medium, up to 25 pounds, and heavy, 50 pounds or more. Whether your job requires you to do repetitive activity, occasional lifting, bending, reaching, twisting, everything about your job that's relevant and important. Hand-eye coordination, motion, standing, going from one department to another, all of those things that you do. Communication with other workers, use of a computer, those are all vocational factors that are assessed. After all the vocational factors are assessed, the judge will submit hypothetical questions to the vocational expert. Why do they use a hypothetical individual? Because that's what the statute, the United States Code, provides under the federal regulations, that they use a hypothetical question. And it'll go like this. Assume we have a 48-year-old individual, past relevant employment, is an order taker, occasional lifting, performing a sit-stand option on the job, lifting of no more than 5 pounds, regular contact with the public. Assume that the individual has the following medical restrictions: no lifting, bending, twisting, no working in hazardous environment, no climbing, crawling, pushing, pulling. Are there jobs that that individual could perform? That's just a typical question. And you're going to walk out of that hearing and say, what are they talking about? I don't understand that. That's not me. No, that's a hypothetical question about a hypothetical individual using all of the relevant information in your case. And when you meet with your attorney should explain that to you so you understand what's going on and what the process is. So now you've got to that hypothetical question. Now you've covered it, you've had a discussion, and here's the way it goes. The vocational expert will classify jobs nationally. For example, they may say there's 100,000 jobs nationally. But then after the jobs are all classified, the attorney has a right, has an absolute right to have the vocational expert identify the job and the skills associated with the job. How much lifting, how much pulling, how much pushing, how frequently, because that's all identified in a book called The Dictionary of Occupational Titles, and the vocational experts use those for all jobs that they don't have first-hand experience with. And believe me, when they use a Dictionary of Occupational Titles, it identifies each job, and it lists whether it's a sedentary job, light job, medium job, or heavy job. It lists whether there's any pushing, pulling, twisting, etc. related to the job, and your attorney can pick apart the jobs by asking the vocational expert if a hypothetical individual with restrictions of no pushing, pulling, lifting, turning, etc., items or handling items that weigh more than 5 pounds could perform the job. And that's the way that you defeat your claim. So, now I've taken you through the process. The turnaround time for a Social Security disability decision is approximately 90 days after your administrative hearing. You'll get a formal decision. The only reason you wouldn't get a formal decision is that your attorney believes that the medical records aren't sufficient and wants a consultative evaluation done. And if the judge agrees to a consultative evaluation, they will keep the record open, or the judge can order a consultative evaluation and keep the record open until the results come back, and then you have a right to respond in writing to the consultative evaluator's assessment of your medical condition. I'm going to sign off now. I haven't had any calls, and I appreciate the fact that you listened. Next week we'll have someone on with me, and we'll talk a little bit more about new areas of the law. So thanks for listening, and have a great day.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers, with Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, Our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?